We have two senators, Senator Ossoff of Georgia, Senator Tillis of North Carolina, who will do their 30 minutes of questioning to complete the agenda from yesterday. And then each senator will be allowed 20 minutes to ask questions if they wish, but the chair is more than anxious to entertain efforts to yield back your time. I'm sure that the witness, Judge Jackson, would appreciate it as much as all of us in that respect. I'm going to make an opening statement. Senator Grassley is going to do the same, and then we will proceed with the questions by the two senators. First, I would say, Judge Jackson, that I thought that President Biden got it right yesterday. He tuned in and watched the proceedings and said you showed both grace and dignity. I've used the phrase grace under pressure, and it's been referred to by many people. This is a tough assignment, and many have risen to the challenge, but none as well as you did yesterday. Thank you for doing it so much. I would just say this, much of what we heard from a handful of senators yesterday has to be put in context. The overwhelming majority of senators on both sides, I thought, were asking appropriate questions and positive in their approach and respectful of the nominee before us. But for many of senators, yesterday was an opportunity to showcase talking points for the November election. For example, all Democrats are soft on crime, therefore this nominee must be soft on crime. Well, you've made a mess of their stereotype. The endorsement of the Fraternal Order of Police, the International Association of Chiefs of Police, just doesn't fit with their stereotype of a Harvard grad, black woman who is aspiring to the highest court in the land. But you earned it. Law enforcement is on your side because you've been on their side at critical moments. And your family has dedicated a big part of their lives to law enforcement, and you obviously believe it at your core. You said that over and over again. So the soft on crime charge, which leads all others, falls on its face. The second thing is that you are somehow out of the mainstream when it comes to child pornography cases. And of course, that gets down to the question of sentencing and your choices in sentencing. It is difficult, if not impossible, for each of us to put ourselves in your place when you are facing all the totality of facts concerning a certain defendant, then looking at your requirements under the law as enacted by Congress and trying to do the right thing to keep America safe, but to meet justice. You are in the same place as 80% of federal judges when it comes to sentencing on child pornography cases. 80%. And of course, Congress is not without fault. We have failed to pick up the responsibility that was assigned to us some 17 years ago when the Supreme Court decided that the basic guidelines would not be mandatory on judges. We should have stepped in at that point. But it's a tough, hard, controversial subject, and we've stayed away from it. And what has happened is the judges have tried to make do with a fractured situation where they have guidelines that are advisory, they have opinions coming to them about sentencing from the government, as well as from probation office and others. So I would say that the bottom line is this. You have done what 80% of the judges have done. You're in the mainstream of sentencing when it comes to child pornography cases. I also think it's ironic that the senator from Missouri who unleashed this discredited attack refuses to acknowledge that his own choice for federal judge in the Eastern District of Missouri has done exactly what you did. You also have been criticized as having been wrong to be a public defender or even to be in a law firm representing a Guantanamo detainee. It's interesting that Republican judges, very conservative ones, don't see this as a blemish on your character. They understand, as we do, that the Sixth Amendment creates a responsibility that people have a right to counsel. You have exercised that responsibility in your professional life. This, incidentally, yesterday, your nomination turned out to be a testing ground for conspiracy theories and culture war theories. The more bizarre the charges against you and your family, the more I understand the social media scoreboard lit up yesterday. I'm sorry that we have to go through this. These are not theories that are in the mainstream of America, but they have been presented here as such. Finally, you are a respected, successful woman of color. You've been approved 3 times by this committee for increasingly significant judicial assignments. Now the President of the United States has chosen you to serve on the highest court of the land. America is ready for this Supreme Court glass ceiling to finally shatter. And you, Judge Ketanji Brown Jackson, are the person to do it. Senator Grassley.
Mr. Chairman?
Yes.
Mr. Chairman, I think you've, in the main, provided both sides an opportunity to be heard and ask their questions. But unfortunately, I noticed that after every series of questioning on this side of the aisle, you choose to editorialize and contradict the points being made by this side of the aisle. I don't know whether we will have an equal opportunity to editorialize about the advocacy that you and your colleagues, the points that you're trying to make. I especially was concerned that after my questioning yesterday, I left the hearing room and you chose to come back after a break and raise with the judge a point that I had asked her about, and which I frankly think was misrepresenting my position and what the facts are with regard to whether the judge has accused President George W. Bush and Donald Rumsfeld of war crimes. My language was, I asked her whether she'd called them a war criminal, and she said under oath to you, no, I did not, although the record is plain as it can be that she accused them of war crimes. Now, I don't understand the difference between calling somebody a war criminal and accusing them of war crimes. Maybe in some other foreign language that I don't frankly understand, maybe that would make sense, but not in accordance with a common understanding of the English language. So I just want to lodge a protest and say that I don't think it's appropriate for the chairman, after every time somebody on this side of the aisle asks questions of the judge, you come back and you denigrate and you attack and you criticize the line of questioning. I think the judge is doing a pretty good job of defending her own position and answering questions. So thank you for giving me a chance to express my objection to the way that you've been editorializing after each time this side of the aisle asks questions.
Thanks, Senator
Mr. Chairman.
Excuse me.
Chairman.
Excuse me. Thanks, Senator Cornyn. It's known as chairman's time.
Could I make my statement first?
You want to make your statement?
Yeah.
Well, may I respond to what Senator Cornyn said?
Well, if you want to speak before you're a
May I?
ranking member,
Thank you.
entirely you're right.
Mr. Chairman, I agree with Senator Cornyn. You and I have talked about this before. I have great respect for you. You know that. But I've had the same issue in normal hearings, non-Supreme Court hearings, where you make editorial comments after I question. I appreciate your input, but they're not offered in an even-handed way. And I just don't think it's productive. I mean, you just referred by name to Senator Hawley. I think he should have a chance to respond. You know, this is America. We have the right to express ourselves. You know, you're not free if you can't say what you think. And I want to join my colleague, Senator Cornyn. I just don't think it's appropriate, Mr. Chairman.
It's called chairman's time. It is a tradition in this committee exercised by Senator Lindsey Graham as chairman and Senator Grassley in previous Supreme Court.
But they didn't do it the way you do it,
I'm
Mr.
going
Chairman.
to allow you to be heard, but I want to be heard
Of course.
without interruption.
Of course.
And so in the minority, we waited through chairman's time when we had Republican chairs. There will not be a separate set of rules for Democrats in control of this committee. That was used as a response time and again by both of those senators, and it was accepted. If what I said was somehow problematic or painful yesterday, I'm sorry, but the Democrats are going to use the same mechanisms that the Republicans have used in this committee.
And I appreciate that, Mr. Chairman. But I think if you're going to personalize it as to senators by name, you ought to give them a chance to respond.
Well, they will have a chance.
Mr. Chairman?
Each and every senator has 20 minutes today to respond if they wish.
Mr. Chairman?
Who's seeking? Senator Ossoff?
Could we hear from Ranking Member Grassley, and then I'd like the opportunity to ask questions on behalf of the state of Georgia. I think the American public is now tuning into these proceedings expecting a substantive discussion of matters of grave importance to the country with a nominee for the Supreme Court before us, I don't think we've set an appropriate tone by bickering over time and process at the outset of our proceedings. Every senator deserves to be heard. I would like to humbly request that Ranking Member Grassley make a statement, that I and Senator Tillis have our opportunity to question the nominee, and that then we can litigate balls and strikes from yesterday's hearing. Would that be acceptable to the committee?
I think in the name of your humility, we should do that.
Thank you, Mr. Chairman.
Senator Grassley?
Yeah. Senator Ossoff, my statement doesn't quite fit in with what you asked, but I feel like I have to say it anyway because of the conflict that happened late last night. But before I do, I want to, somewhat tongue-in-cheek, but with some seriousness as well, when the chairman quoted Biden as saying that Justice Jackson, or Judge Jackson, handled herself with grace and dignity. I want to compliment the Democrats on this committee for using grace and dignity, unlike it was during the Kavanaugh hearings. Thank you all very much for making this. I've heard a lot of compliments about how this is a way a hearing ought to be held. So I want to address that issue that was raised yesterday about records. Senator Cruz raised a very legitimate question about data related to U.S. probation officer recommendations. The White House and members of this committee used that information to attempt to discredit information raised by Senator Hawley and others about the nominee's sentencing record as a district judge. No one on our side of the aisle had access to this information. In fact, before this past week, I'm not sure anyone but the probation office and the court had access to this information. My understanding is that the probation office recommendations aren't part of any public record. The specific sentencing recommendations aren't always shared with prosecutors or defendants. Somehow it appears that the White House obtained this information. It was leaked in pieces to media outlets in order to cast doubt on legitimate members' questions, and then it was provided to only Democratic members of this committee without any of the underlying documentation. I'd like to add my name to the letters that are requesting at least, this is Senator Lee's letter, request for at least the probation office recommendations so that we can be sure of the data handed out by Democratic staff last night. I'd also like to add my name and have added my name to Senator Cruz's follow-up request for access to any other data that might be shared with our colleagues on the other side. One last thing to suggest that all that we have to do is ask for information doesn't pass muster. You can't ask for information you don't know if it exists. I've asked for non-public records related to the judge's tenure on the Sentencing Commission. Those have not been produced, just like 48,000 pages of records withheld by the White House. How is the United States Senate supposed to review a record that we don't have? This process might be timely, but it's neither thorough nor fair to the American public, and I hope we can rectify that. I yield.
Thank you, Senator Grassley. Senator Ossoff.
Thank you, Mr. Chairman, Ranking Member Grassley. And Judge, good morning.
Good morning, Senator.
Welcome back.
Thank you.
We had a late night doing our job as senators and you as a nominee, and we're off to a morning start. I was considering asking you if you were a coffee or a tea drinker, but I thought that might be too personal and immaterial to the question of your nomination. I want to begin inspired by the presence of my brother, Senator Reverend Warnock, who's joined us this morning, in a spirit of national unity, offering thanks for these proceedings, for our Constitution, for this opportunity to air in public before the American people a vital grappling with ideas core to our republic, questions of the role of branches of government, questions of the proper role of judges in our society, questions that keep the peace and ensure that this remains a nation of laws. As I noted in my opening statement a couple of days ago, democracy is the exception and not the norm in history or around the world. And this public exercise is a vital one. And so I'm thankful for it. I'm thankful that the American people have the opportunity to observe it. And I'm thankful for your presence, Judge, for your service to the country throughout your life as a district judge, as an appellate judge, as a member of the U.S. Sentencing Commission, as a nominee for the court. So thank you for being here. Thank you for subjecting yourself and your family to an intrusive, at times cruel and unfair, but on the whole necessary and proper process of scrutiny as you are considered for this appointment. The American people who are now tuning in for the second day of these proceedings are hearing about your approach to the law, to your role as a judge and as a potential Supreme Court justice, and they're also getting to know you personally. And we've had the opportunity to hear a bit about your family, your background. I think it's also appropriate that the American public hear a bit more about your brother's story. As I understand it, served the Baltimore Police Department, served in the U.S. Army. Before we turn to matters of law, will you please help introduce yourself and your family to the American public as you seek this lifetime appointment? Tell us a bit about him and his story.
Thank you, Senator. My brother followed in a long tradition in my family of public service. It was a core family value. My parents were both public servants, and two of my mother's brothers were career law enforcement. And my brother and I are almost a decade apart in age, and he, I think, looked up to my uncles who were often around in their uniforms, keeping their weapons away from the kids by putting them up on high shelves, and we looked up to them, and we understood through their service what it meant to give back to your community. My brother went to college, a historically black college, Howard University here in Washington, D.C., after growing up in Miami, and decided to follow in my uncle's footsteps. He could have done many things coming out of college with a college degree, but decided he wanted to be a police officer and went to Baltimore, which, as many of you know, struggles, like many cities, with areas that have a lot of crime. And it was a very stressful period for us as a family, because as proud as we are of his service, as much as we know it's important, law enforcement is a dangerous profession. And as family members, you worry when you don't get the phone call, when you haven't heard for a couple of days, when you hear about things in the news, in the community, you worry. And so I grew up with family members who put their lives on the line. I understand the need for law enforcement, the importance of having people who are willing to do that important work, the importance of holding people accountable for their criminal behavior. I also, as a lawyer and a citizen, believe very strongly in our Constitution and the rights that make us free. And what that means to me is an understanding that although we need accountability, although there is crime, we also have a society that ensures that people who have been accused of criminal behavior are treated fairly. That is what our Constitution requires. That is what makes our system so exceptional. My brother understood that as part of his work, and he also served in the military. he also decided, as many people did, to defend our country after 9/11, that he would go into the Army. And I remember when he made that decision, he had a college degree. He could have been an officer right away. He could have been a type of military officer that didn't have to actually be on the battlefield. And I remember saying, are you going to do something with, radio signals? Are you going to be behind the scenes? And he said, no, I'm going to be infantry, boots on the ground. He said, I believe strongly in the protection of our country, and if I'm going to be leading, I'm going to be out front. That's the kind of person my brother is. It's the kind of service that our family provides. And for me, what that meant was an understanding that to defend our country and its values, we also needed to make sure that when we responded as a country to the terrible attacks on 9/11, we were upholding our constitutional values, that we weren't allowing the terrorists to win by changing who we are. And so I joined with many lawyers during that time who were helping the courts figure out the limits of executive authority, consistent with what the framers have told us is important, the limitations on government. I worked to protect our country. My brother worked on the front lines, and it was all because public service is important to us.
Thank you, Judge Jackson. And let's talk a bit about limitations on power. Our Constitution is a document that renounces monarchism and instead establishes a republic. You, in opinion that has been widely cited, made the observation that presidents are not kings. What does that mean, and what are some of the most important bulwarks in our constitutional system against the abuse of executive power, against tyranny?
Thank you, Senator. Our constitutional scheme, the design of our government, is erected to prevent tyranny. The framers decided, after experiencing monarchy, tyranny, and the like, that they were going to create a government that would split the powers of a monarch in several different ways. One was federalism. It was vertical. They would split the powers between the federal government and states. Another was to prevent the federal government from itself becoming too powerful, from having all of the authorities, from having legislative, executive, and judicial authority concentrated in one place. So the Constitution, in its design, puts the legislative authority in Article 1 and gives it to the Congress, the power to make laws. It puts the executive authority in Article 2 and gives it to the president, the power to execute the laws. And it puts the judicial authority, the power to interpret the laws, in Article 3 and gives it to the court. The separation of powers is crucial to liberty. It is what our country is founded on, and it's important, as consistent with my judicial methodology, for each branch to operate within their own sphere. That means for me that judges can't make law. Judges shouldn't be policymakers. That's a part of our constitutional design, and it prevents our government from being too powerful and encroaching on individual liberty.
Thank you, Judge. I mentioned in my opening remarks that the court has played a vital role, constrained within its proper constitutional boundaries, in the national process of making America in real life what America is in text. And reflecting on your experience as a public defender, a vital role in our justice system. Let's talk a little bit about the Sixth Amendment and the role that the court played in ensuring that the Sixth Amendment is real in practice in the Gideon v. Wainwright decision. Can you help all those who are tuned in right now to reflect upon that decision, what it means, what it says about the role of the court?
Yes, Senator. Prior to Gideon versus Wainwright, people who could not afford lawyers were not entitled to lawyers under our system. So a person could be accused by the government of criminal behavior and would have to fend for themselves in court. They would have to make their own arguments. Someone who is not a lawyer would still be responsible for defending him or herself in front of a judge if the government brought charges. Earl Gideon was a criminal defendant from Florida, my home state, who had a handwritten petition. He complained that it wasn't fair under our constitutional scheme that protects and requires people to be tried. He said, I need help. I'm not a lawyer. I can't make these arguments. I think it's important for the protection of liberty to ensure that people are able to have counsel. And that handwritten petition made its way to the Supreme Court. And the justices read it, and they determined to take his case, and in the end decided that the protections of the Sixth Amendment, the right to trial, includes the right to appointed counsel, so that everybody who is accused of criminal behavior now has the right to an attorney. And that's very important. I mean, one of the things that I see or saw as a trial judge is that it was crucial for our justice system to have representation from both sides. It was the only way that it is the only way that a judge can really make fair determinations. And in cases, we've heard a lot about my criminal cases. In every case, I'm getting, as a judge, arguments from the prosecution. I'm getting arguments from the defense counsel. I'm getting arguments or statements from probation in these criminal cases. And the work of a judge is to look at the facts and circumstances, hear the arguments of the parties, apply the law, and make a fair determination. And so having lawyers for criminal defendants aids in that process and benefits us all in our criminal justice system.
I would just take the opportunity to note at this time, Judge Jackson, that it so happens that the Southern District of Georgia is one of just 3 federal districts without a federal defender's office, and I've offered legislation to establish one, and I'll be seeking support from my Republican colleagues to try to make that bipartisan to ensure there is access to counsel for defendants in my state. Let's talk a bit about the First Amendment, freedoms of speech, publication, assembly. There's a well-known Supreme Court case, Brandenburg v. Ohio, which establishes a certain test to ensure that the government is constrained in any effort that may be made to punish speech. And the impulse to censorship is something that can emerge from time to time across the ideological and political spectrum, particularly in times of great controversy or in times of national security crisis. Can you please walk the committee and the broader public watching now from all across the country through that decision and how you will approach these vital protections for speech, publication, and assembly, should you be confirmed?
Thank you, Senator. Freedom of speech, publication, assembly is in the First Amendment of the Constitution. It is a core foundational protection against censorship. It is important in our constitutional scheme that people be allowed to express themselves, that ideas be exchanged. That is the groundwork for a vigorous and vital democracy. There are many tests, many cases in the Supreme Court's jurisprudence that discuss various disputes about circumstances in which the government can restrain or regulate speech. And that decision establishes to a certain extent that if there is speech that is an incitement to violence, that's one circumstance in which the government might be able to prevent it. But other than that, short of that, free speech is supposed to be allowed to happen. And there are, again, various tests and circumstances that the court has applied in deciding whether the government can regulate the content, place, and manner of speech. But the general principle is that our democracy thrives because the government is restrained and cannot censor its citizens.
I think in the same spirit of thanks with which I opened these questions, I also want to just take a moment and recognize the members of the press who are here, the reporters and photographers who ensure that these proceedings are truly accessible to the public, and ask you to describe your approach to press freedom. The question of prior restraint has been litigated. A famous case in the context of the Pentagon Papers in the latter years of the Vietnam War. I believe for all of us on this committee, we recognize the vital role of press freedom in ensuring the free exchange of ideas, access to truth and debate in our democracy. How will you approach cases that implicate press freedom?
Thank you, Senator. This is another area in which there is well-established case law that supports the freedom of the press to be able to write and report. There is a general obligation of truth in terms of the press, but also a recognition that sometimes there may be things that get published that aren't exactly accurate. And so the court in New York Times versus Sullivan determined a higher standard of liability for press. Things that are put out in the press have to be knowingly false. There's an actual malice test because the court was balancing concerns about libel, people claiming that they have been misrepresented in the press, with the need to allow the press to do their job. The overall understanding is that press freedom, again, is one of the First Amendment freedoms that undergird our democracy.
Something I just want to take a moment and observe, Judge Jackson, is, and this is my first such proceeding. So I'm grateful to the chairman for opening today's ceremonies at the end of the dais. But something that I've studied and am aware of is that there's been a range over time of how willing nominees are to candidly and openly and forthrightly discuss these core matters of constitutional principle in proceedings like this one, and a tendency over time to allow less and discuss less, a more restrictive approach. And I want to thank you because while you have prudently and in a disciplined way refrained from commenting inappropriately on potential pending case law, you have been willing to engage in a forthright and expansive discussion of these vital principles in a way that I think stands out among some recent nominees. That's not a criticism of any recent nominees. It's an observation about your performance, and I think that having an open and honest and forthright dialogue about these matters of national significance is part of the vital role that these proceedings serve. I want to turn now to the Fourth Amendment. I want to discuss with you the protections against unreasonable search and seizure. We discussed how the Constitution was a renunciation of monarchism and tyranny. It establishes core civil liberties, one of which is the protection against unreasonable search and seizure. How will you approach Fourth Amendment case law, and can you help those tuned in across the country remind them of what, for example, the principle of a reasonable expectation of privacy means in the context of Supreme Court jurisprudence?
Thank you, Senator. The Fourth Amendment is one of the amendments in the Constitution that protects individual liberty by limiting what the government can do with respect to criminal processes. It restrains the government from engaging in unreasonable searches and seizures. And the Supreme Court has developed a series of tests and ways of evaluating whether any particular act by an officer in a case qualifies as an unreasonable search or seizure. Let me just say that this is the kind of area of Supreme Court and judicial review that is very fact-specific, because courts, in order to stay in our appropriate role, can't make policy about police behavior writ large. Can't just sort of look out into the universe and say, we have a Constitution that says unreasonable searches and seizures, so let us tell you all what that means. That's not the way that courts operate. Under Article 3, courts can only hear individual cases and controversies and decide them. So every court, including the Supreme Court, is looking at unreasonable search and seizures in the context of a particular dispute where someone has had something searched by an officer in their house, they've been seized under a particular set of facts, and they claim in the context of a lawsuit or in the context of defending themselves that there has been an unreasonable search or seizure. And so the court, case by case by case, looks at the facts and circumstances and decides. And I would say that this is the kind of analysis that takes into account a number of things, but one of the things, in addition to understanding the facts and circumstances, is understanding what is meant in the Constitution by unreasonable search and seizure. There is case law that the Supreme Court has developed that looks at whether or not something is an unreasonable search and seizure, in part by analyzing whether there was a reasonable expectation of privacy in that item, in that area. Is there a reasonable expectation of privacy in your house, for example? If a police officer were to come into your house, you would not be able to claim Fourth Amendment protection unless, says the Supreme Court, there was a reasonable expectation of privacy in your house. And the Supreme Court has determined whether there's a reasonable expectation of privacy, for example, in your house, by looking at what areas were protected at the time of the founding when the words unreasonable searches and seizures were written into the Constitution. Lo and behold, something like your house, the court has determined there is a reasonable expectation of privacy because that's what those terms meant back then. And so if a police officer were to come without a warrant, the court has said, in areas where there is a reasonable expectation of privacy, that would be an unlawful search.
This is an area where the emergence of new technologies makes it likely, I believe, that should you be confirmed, you will have to consider Fourth Amendment claims in light of circumstances that couldn't have been anticipated at the time of the drafting of the Constitution. And indeed, constitutional interpretation has already evolved over time to adapt to the reality of new technologies. From phone booths, a classic case in the late 1960s about whether a closed phone booth door demonstrates an expectation of privacy, to more recent case law involving geolocation data from cell phones. And I want to urge you, should you be confirmed, to remain vigilant about how the emergence of new technologies, the way that they become ubiquitous in our lives, the way that virtual spaces are increasingly akin to physical spaces, will require the court to consider very complex questions and to seek technical advice, because these are technologically complex questions. What is your view on how the court should seek such technical expertise, which may be, with all due respect, beyond the training or experience of a justice or their clerk? And if, for example, one such method of seeking advice is through amici, what's the importance of understanding the provenance and origin and funding source of such briefs submitted to the court? So this is a two-part question. I want to restate it. The first is, again, I want to urge you, should you be confirmed, as I'm confident you will, to vigorously defend the constitutional rights of American citizens against unreasonable search and seizure in the context of new technologies. I'd like to hear how you'll approach seeking technical expertise to inform that decision-making. And then a question about the transparency of briefs filed before the court, something that Justice Scalia noted in some campaign finance case laws, that it's important for the public to know who's funding electioneering communications in the context of political campaigns. I think it's important for the court to know who's briefing them, what the motive and funding source of such briefs might be. Could you please, with my remaining time, and then I'll yield and we'll have some more time later to discuss war powers, could you please comment on those matters? Those will be my final questions for this round.
Thank you, Senator. One of the ways in which the court receives information other than directly from the parties in a case is through a practice, an established practice of receiving amicus briefs. Amicus is a term for friend of the court briefs. These are people who are not parties to the case, who don't have that kind of interest in the case, but may have expertise or information or arguments that they wish the court to hear. And I think that that would be the primary mechanism by which, if the court were to decide to hear a case concerning a matter that involved some technical expertise, I would think that there might be amicus briefs related to the technology, for example. I have not looked at the court's rules. I would certainly want to discuss with the court's other justices the ways in which determinations are made about which amicus briefs are received and what disclosures are related to them. But the court does receive amicus briefs in cases in order to inform itself so that it can make a decision related to the issues in a case.
Thank you, Judge Jackson. Thank you for your courage and your grace, your forthrightness in answering my questions. I look forward to the opportunity to ask a few more later, and I yield, Mr. Chairman.
Thanks, Senator Ossoff. Senator Tillis.
Thank you, Mr. Chairman. Judge Jackson, thank you for being here. I hope you got some rest last night, and congratulations.
Very little, Senator, but that's all right.
Me too. But thank you for being here, and congratulations to your family and your husband, who has an impressive medical list of accomplishments that he should be proud of. I'm sure that you are too. And thank you to your family, the public servants, serving in the military, serving in law enforcement, educating our children. You're a role model family. I do want to go back. This morning, I ended up turning to a channel that I never watch, just to see what was being said about the proceedings. I thought it was interesting that they were ridiculing some of my colleagues on this side of the aisle for bringing up the behavior of past Supreme Court hearings. This is really the appropriate venue to do it. I guess we could talk about it when we're reviewing intellectual property or something else, but contextually, this is the time to do that. And I think we all have to agree that the behavior in the Kavanaugh hearing was inappropriate. I hope we never get back to it. And I hope we can all agree that many of the behavior or the positions that some of my colleagues took on the other side of the aisle with Justice Barrett was abhorrent, and we should never do it again. That's why I'm so glad that for the most part, we behaved in an appropriate manner here. I'm going to get to some questions, if time allows, that relate to some other questions that my colleagues have asked. But Judge Barrett, did I understand correctly that at a young age you won a debate competition, or was it oratory competition?
I was in speech and debate. It was one team, and I did original oratory as my primary event.
And did you continue your debate competition? Did you continue to do that? First question. Did you continue to do debate competition?
Continue into college?
Were you doing that in school and college?
I did not do it in college. No, I did it from middle school through high school.
Okay.
And stopped when I graduated high school.
I did too, and I recall with that we would get assigned a topic that wouldn't necessarily be one that we agreed with, but we had to argue it. Were you ever in a situation, or did you get to pick a topic and only argue the side that
So I didn't do what it sounds like you're referencing is extemporaneous speaking.
Yeah.
I think I did that once in one competition. I did original oratory, which is where I wrote my own speech.
Okay, you've had an opportunity to debate a lot as a defense counsel, I would assume, in the court of law when you're debating a position. And the reason I ask that question is that yesterday when Senator Kennedy was asking you about the expanding the court, or what we call court packing, you said, I haven't really thought about it, but I hear the arguments on both sides. And I hear the argument on both sides. So could you briefly describe to me your perception of the arguments on both sides?
My understanding of the argument is about whether or not to expand the court beyond the 9 justices that are on the court right now, the 9 seats that are there. And
if you were to view, right now it's 9 is fine, 4 or more. That's really the 2 arguments. So do you understand, or have you heard any of the arguments for or against either side?
I'm not even sure about the 4. I've just heard people talking about putting more justices on the court, expressing concerns that the court has become politicized, that the court has become unbalanced in terms of what people perceive to be views of the majority of the justices. And so I've heard arguments about rebalancing the court on that side. And then there's the argument that many on the dais have stated about the inappropriateness of doing so, the concern that it might lead to some kind of a war of every time there's a new president adding justices to the court.
Actually, yesterday when Senator Whitehouse, I think it was Senator Booker, who observed Senator Whitehouse's presentation, made a comment about how Rhode Island, New Jersey being a bit bigger, would have a bigger graphic to display. I went back, I think that New Jersey is 6 times the size of Rhode Island by square miles. North Carolina is 36 times the size of Rhode Island. And before my friends from Texas chime in, I would let them know that if Alaska were 2 states, they'd be the 3rd largest state. So I'm decided to use the White House format for dark money so that we have a balanced understanding of the fact that our proceedings here, the aspirations for the court. There is an ecosystem out there on both sides. As a matter of fact, we had a judicial nominee who actually participated in this ecosystem. I think you could reasonably assume if they participated in that ecosystem that they probably would have been an activist judge. The point that I make here is that we've seen this ecosystem mobilized to support you, and I think, Judge Jackson, you said you haven't had any encounter with demand justice. I don't know if you've had any encounter with some of these that are abbreviated, or I'm sorry, either acronyms or abbreviated, so I wouldn't expect you to. It would be interesting if we could, for the record, determine if you have had any interactions, but with respect...
I have not, Senator. I've never seen most of those.
That's good enough for me. I wouldn't expect you to be honest, sitting on the bench, but they are out there, and they have a specific plan. And their specific plan, as a matter of fact, I was inspired by Senator Whitehouse's seat, so I went out to demand justice. They have a specific plan. Step 1, 4 seats on the Supreme Court. We must add 4 seats on the Supreme Court to restore balance, which by their opinion is a majority with their view and their judicial philosophy. They're thrilled that President Biden has promised to appoint a commission. In fact, they're so thrilled that they want to make sure that they can influence the outside of the commission by endorsing their 4-seat strategy. They want to recruit 25,000 volunteers. This is on their website, their strategy, to influence the commission's recommendation. And then they want to nuke the filibuster. 51 votes to make a decision that could ultimately be to pack the courts. This is their stated goal. They're proud of it. Senator Whitehouse was talking about how the prior president was influenced by an organization. I would say that Senator Jackson and almost everybody that the president vetted before, Judge Jackson, are on this list. So I think it's intellectually dishonest to say that the administration, that my colleagues on the other side of the aisle, are not influenced by this organization. We've tracked some of the fundraising and support in re-elections. They're engaged, and they're influenced by it. But let me tell you what I'm really worried about with the court packing risk that we have today. We're talking about the ultimate destruction of 2 institutions. Back in January, Senator Schumer laid a vote down on the floor that ultimately would have reduced the majority of 60, the filibuster limit of 60, to 51. He was doing it as a way to pass a single bill, but we all know what happened when Senator Reid nuked the executive calendar for circuit court judges. It led to you only being subject to 51 votes to be confirmed. That nuked the executive calendar. In January, Senator Schumer was laying the groundwork for the same thing. Now, I worry that's the destruction of the Senate institution as far as I'm concerned. I think we have to be a consensus-based organization. We don't need to be a 100-member House of Representatives. And that vote happened. What disappointed me most about that vote is back when President Trump was calling on us and pressuring us to nuke the filibuster when we had control of Congress. I signed on to a letter with more than 60 members to say that I would never do that in the face of a Republican president whose policies I supported. I did that to send a very clear message. I respect this institution, and I respect the court, which almost certainly would have been, we would have had pressure from our side of the aisle to pack the court a little bit more. Now, every member who was here back when we signed that letter, who's on this committee, changed their position and voted to potentially nuke the filibuster just 2 months ago. So I hope you can understand my concern about the political wins and the potential damage that it could do to the Senate and do to the Supreme Court. I think it was Federalist Paper 78 where Hamilton talked about the vulnerability, or I think the feebleness. Now, he was arguing, I think, the case for lifetime appointments. But I do think that the Supreme Court is a fragile institution. And I do believe that if we think it's politicized now, think about how it would be if we destroy the institution of the Senate so that a strict party line partisan vote, we expand the court. That's why court packing is important, and that's why we ask a question that I know you're not going to answer, but I know that Justice Breyer and Justice Ginsburg did. And if there's any Supreme Court justice listening right now, I wish that they would speak up, because I think your institution is in peril, and accelerating it to a truly political body is only one successful nuking of the filibuster vote away in the U.S. Senate. This is serious stuff. I was at Price Waterhouse. I was a partner at Price Waterhouse back during the Arthur Anderson Enron scandal. I saw about a 100-year-old top-tier Big Five consulting firm cease to exist because their reputation suffered. If we pack the court, the only thing that you all have, that the Supreme Court has, is its integrity and the esteem that the American people and the trust that they put into it. Packing the court could cause the Supreme Court to lose the trust of the American people. And I think if we want to expand the court, let's do it for the only valid reasons. Maybe the justices come to us and the Chief Justice come to us and say, the workload is too great. The times have changed. And then convince 60 members of this body to consider it. But when you've got a partisan organization here that's putting a pipeline of people in there that they think like them and have a judicial philosophy like them, how can any reasonable person think that this is just kind of fixing the mechanics? It's a partisan decision that even some of my colleagues on the other side of the aisle have taken the bait. So much so that they would reverse a commitment that they made with me when they signed that letter to say they would never nuke the filibuster and then nuke it. President Biden's on that list too. Back in 1983, he gave a rousing speech in a Judiciary Committee hearing saying, don't pack the court. He gave a rousing speech on the Senate floor saying, don't nuke the filibuster. But now we're in this posture to where we could destroy two institutions if we're not careful. So I actually hope that you can at some point study the issue thoroughly and understand the risk to this institution that you're likely to be confirmed to. It's serious. And you could end up being there. You'll have a lifetime appointment. You could actually be there and witness its demise real time if we allow the court to be packed. Now, I want to talk a little bit about I think you were a part of a case in Massachusetts that some people are casting as a pro-life versus pro-choice issue. Now, to be clear, I am Catholic and I am pro-life, and I'm proud to have signed and ratified pro-life bills in North Carolina when I was Speaker of the House that have withstood judicial scrutiny. But I don't really think that case was about pro-life. I think it was about free speech. So I want to ask you a few questions about it. And maybe you could describe it to me if your memory serves you. But it seems to me that the argument that you were a part of, I think that you joined with a couple of others, it seemed as if the argument was because the pro-life protesters were threatening and dangerous to women, attempting to enter the clinic. I'm not necessarily saying you put those words in the brief, but they were in there, and they were a hostile, noisy crowd in the face of protesters. Now, am I correct that a part of the argument was because they were noisy, in-your-face protesters, they needed to be a little bit further away than people who were pro-choice advocates? Because as I understand it, I think the underlying law in Massachusetts was ultimately struck down unanimously by the Supreme Court. Is that correct?
Thank you, Senator. The brief that you...
Oh, by the way, I didn't expect you to respond to my riff on packing the court.
Yes.
Just to net it out, it's a bad idea. But back on this.
I understand. The brief that you are referencing was a brief that I worked on right after finishing my Supreme Court clerkship when I joined a big law firm in Massachusetts. This is maybe 2000 at the end of my clerkship. And it is a First Amendment free speech set of arguments that the lawyers at my firm, I was a part of a team representing clients who wanted to make an argument about buffer zones, which at that time had not yet been litigated all the way up to the Supreme Court.
Was it a buffer zone that put pro-life and pro-choice people in the same buffer, or one that argued that pro-life people were in your face and perhaps needed a bit better, bigger buffer than the pro-choice? I was just trying to understand the facts of the case.
I believe that it was viewpoint neutral, meaning it wasn't about what the people were saying. It was about clearing a path to allow people to enter the clinic. Mm-hmm. The laws at the time were about how far did people have to be kept back, whether they were pro-life or pro-choice, because if they were blocking the entrance.
Do you understand why the underlying law was ultimately deemed unconstitutional by the Supreme Court?
I didn't follow the jurisprudence at that time. It had not been. And the First Circuit, this was a First Circuit brief. I don't remember what happened in the district court, but my clients wanted to argue in the First Circuit that the laws that allowed for the clearing of the path so that people could enter the clinic and have people stand back were constitutional and important, and the First Circuit agreed. I think ultimately, I don't know exactly, but I think ultimately, as you say, there was some litigation that went all the way to the Supreme Court, and the court had other jurisprudence about the extent to which buffer zones are constitutional.
Yeah. Well, it looked at. I'm not an attorney. I watch Law and Order from time to time, and I'm not going to get into a debate. But on its face, it almost looked as if there was this notion that there was bad speech and good speech. That somehow. Look, I'm somebody who's had protesters come to my house, get in my face, and be very nasty. 4 times by land and 2 times by sea. I live on a lake. Okay with them doing it as long as they stay off my lawn. In the last case, they didn't. But it almost felt like to me that those protesters who didn't like me needed to be a little bit further away than the protesters that maybe I would allow to be a little bit closer. It may not be right, but I'll make sure that I get my facts right before this afternoon in the second round. I want to go to sentencing. I'm not going to cover any of the ground that my colleagues have. I'm sympathetic to some of it, not necessarily all of it, because I think the details are something that we don't have possession of. I'm sure we're going to talk a little bit more about that. But I want to talk more about a pattern. I know, and I was really impacted by your description of family dinners and your uncles coming in uniforms and putting their guns up on the cupboard and having a sense of pride that you had family that served in law enforcement. There are a couple of cases. I'm very focused on law enforcement and backing the blue. I think that law enforcement, I talk with a lot of them, their morale is low. They feel like defund the police and some of these other efforts are already making a very difficult and dangerous job more difficult and more dangerous. There have been a few cases where you have recommended lower sentences that even I think the defense attorneys have. But I'm sure that if I were you and observing you yesterday, you would probably point to some mitigating circumstances or factors that are not necessarily available to the committee as a basis for doing that. I think in one case, the government recommended a 30-month sentence, and the defense recommended 21 months, and you gave them 18 months, and this was a third conviction for assaulting an officer. There was another one that was a lower sentence for, there were officer assaults, and it just seemed like it went lower. But I don't want to get into those because you may have factors that that you would point to that would justify the decision. I've got a question about, see, that's at an atomic level. I mean, you're looking at the facts of the case, you're looking at the defendant, and as you've described in some of the other cases here, you made a judgment that you thought was fair and that was in bounds with your peer group. But back at the beginning of the COVID pandemic, I believe you made this statement, and I'll give you time to provide context if it's out of context, but in the interest of time, I'm only going to read the most striking. You said the obvious increased risk of harm that the COVID-19 pandemic poses to individuals who have been detained in the districts, that's the District of Columbia's correctional facilities, reasonably suggests that each and every, and I think that means everyone, every defendant who is currently in the D.C. Department of Corrections custody and who thus cannot take independent measures to control their own hygiene and distance themselves from others should be released. I checked in April of 2020, I think that's when you made the statement, that there were 12 or 1,600, let's call it 1,200, I'll be conservative, people in the Department of Corrections. Do I read that statement to say that you felt, given the circumstances of the time, they should all be released? Because that's broad. That's not looking at their individual cases.
No, Senator, you don't read it correctly.
Okay.
It was not a statement. It was a line in an opinion, and the beginning of the COVID-19 pandemic was a really, obviously, horrible and difficult time for all of us. Yep. And what was happening at the beginning in the prisons, which was part of the criminal justice system that as judges we were involved in.
I tracked it quick. Because I do not want to go over. I don't go over. But let me just give you a little bit more context. I've actually written letters to the Department of Justice encouraging the release of nonviolent offenders in North Carolina at a federal correctional facility. I've also supported early release programs. I voted and supported the First Step Act. I, as Speaker of the House, was the first speaker in probably 2 decades that actually did the Justice Reinvestment Act early release of nonviolent prisoners. But how can I not read this to say that perhaps they should be released irrespective of the crime for which they've been charged?
Senator, if you read 2 more sentences down, that is precisely what I focus on. This is a case, United States versus Wiggins, where I was setting up my analysis as to why I would not be releasing Mr. Wiggins in this case. He was arguing essentially what I said in that statement. He was arguing that the circumstances of COVID-19, which at that point was rampant in the prisons, we had not had a vaccine. There were very difficult circumstances for prisoners who could not be separated from each other in the context of our jails. And as I say at the beginning of that opinion, at that point, COVID was ravaging the jail. And the question for courts under the statute that Congress has enacted for compassionate release was whether COVID-19, a pandemic in the jail, was an extraordinary and exceptional circumstance or extraordinary and compelling circumstance that should warrant release. What I said in that statement that you read was it would seem as though something like a deadly pandemic rampant in the jails would justify releasing everyone. But I go on to say in that very opinion, Congress has indicated that we have to take each case individually. We have to look at the harm to the community that might be caused by the release of individual people. We can't just release everybody, I said in that opinion. And so
I wanted to give you, I'm sorry to interrupt you, but I'm on,
That's all right.
on 4 minutes. But I feel like I also had my staff provided me this morning in very, very small type, recidivism and federal sentencing outcomes. I've said, I'm on record as saying that I want people out. I want them to have them an opportunity to reenter society, become productive members, and I've got a track record for ratifying bills to that effect and supporting similar measures since I've been here in the Senate. I'm going to continue to work on it. But tell me why the numbers that I'm looking here, we have recidivism rate, the most recent one that I have before me, and I'd be happy to share it. I'll ask to have this submitted to the record. But I think an 8-year look back says that 49% of the people incarcerated are rearrested within 8 years. If you take a look at the types that are most likely to be reoffending, it's firearms offenders, robbery offenders, violent offenders reoffended at a higher rate than nonviolent offenders. And so if I look at this and I look at your philosophy with respect, and it's admirable. I said that the content of your character would be demonstrated this week in my opening statement, and it has been. And one of the things that are first among them are your compassion and your belief that people can redeem themselves. But if you look at some of the cases that my colleagues have brought up, and if you look at even with the context that you provided on the last statement about the Department of Corrections statement in Wiggins, can you understand how some of us may think that your compassion could lead to bad results based on the numbers that we have here with recidivism, that Congress may need to work more on that to make sure that we get it right? Can you understand how somebody who, from our side of the aisle, could see that maybe there is some pattern to give the benefit of the doubt to someone who has been incarcerated, in some cases with very serious crimes?
Thank you, Senator. I don't recall saying anything about compassion in the way that you're describing it.
No. I'm just saying that if I take a look at your responses to some of my colleagues' questions and your statements to some of the defendants, it seems as though you're a very kind person and that there's at least a level of empathy that enters into your treatment of a defendant that some could view as maybe beyond what some of us would be comfortable with respect to administering justice.
Thank you for letting me clarify. The statements that I made about my practices as a trial judge, which I'm no longer a trial judge, but were intended to explain how trial judges operate and how they impose sentences within the framework that Congress has provided. The statute that applies to us tells us to look at all of the various factors that Congress has set forward, including the nature and circumstances of the offense, the history of the and characteristics of the defendant, and it tells us that we should be imposing a sentence sufficient but not greater than necessary to promote the purposes of punishment. Congress also tells us that one of the purposes of punishment is rehabilitation. My attempts to communicate directly with defendants is about public safety, because most of the people who are incarcerated via the federal system and even via the state system will come out, will be a part of our communities again. And so it is to our entire benefit, as Congress has recognized, to ensure that people who come out stop committing crimes. And so what I convey, or did when I was a trial judge, as I sentenced people to very lengthy periods of incarceration, was you are getting your day in court. You are able to say what you want to say, but you have to sit here and listen to my reading into the record the victim's statements in this case. You have to go away understanding that I am imposing consequences for your decision to engage in criminal behavior. And the reason why I did that, I've said, is because I recognized as a defender that there were lots of people in our system who, instead of taking responsibility for what they had done and then ultimately understanding the harm and potentially not doing it again, instead of that, those people were bitter, they were angry, they were feeling victimized because they didn't get a chance to say what they wanted to say, because nobody explained to them that drug crimes are really serious crimes. Nobody said to them, do you understand that there are children who will never have normal lives because you sold crack to their parents and now they're in a vortex of addiction? Do you understand that, Mr. Defendant? I was the one in my sentencing practices who explained those things in an interest of furthering Congress's direction that we're supposed to be sentencing people so that they can ultimately be rehabilitated to the benefit of society as a whole.
I appreciate that, Judge Jackson. I just still note that virtually half of those people, statistically speaking, that you gave that speech to within 8 years were back in prison, and in some cases for more serious offenses than the first incarceration. Thank you, Mr. Chair.
Thanks, Senator, for that line of questioning. And I've noted that you joined a letter with Senator Grassley and myself in March of 2020 at the earliest stages of this, talking about release under these similar circumstances. And of course, we all said at the same time, low risk inmates would be considered, but
only low risk inmates.
Yes.
Yep.
And I wanted to make that note for the record. We're going to start the second round of questions, 20 minutes each, and I'll kick it off. This is an unusual document, this Constitution of ours, which has taken up so much time in the hearing, the conversation about it. And it is really at the core of public service. I don't know that there's a place that you can take a job at the federal level in any branch of government without taking an oath to defend this document. I don't know about other countries and the oaths that might be required, but we even within the Constitution spell out the oath to be taken by the President of the United States, and it's to uphold and defend this document. And there's great debate about just what this document means in today's context. We understand the wisdom, the inherent wisdom of the document, and the fact that we're still here some 230 years later with the design of a government that has endured longer than virtually any other democracy, which, of course, speaks to the wisdom of the Founding Fathers and their plan for this nation. But we also understand, taking an honest look at it, that you barely get into this document, Article 1, Section 2, then you run into a problem. Because in Article 1, Section 2, the article that relates to Congress, they talk about who will be counted for apportionment among the states, and there is that awful reference to 3/5 of all other persons, which, though the document never mentions the word slavery or slaves, what was being spelled out here by the Founding Fathers was, how are we going to count these slaves? And for apportionment purposes, they were to be counted as 3/5 of a person, which is a horrible notion by any standard, but the wise Founding Fathers included it, trying to deal with the reality of their day. I hear debates back and forth of originalists, textualists, and others, and you've been asked as often as any nominee what your thought is. You've talked about stay in your own lane judiciary and methodology and like. But I'd like to explore for just a moment, without asking you to get in any particular fact pattern, the reality of a couple things. First, when the Bill of Rights was written, the First Amendment to it made certain to guarantee freedom of press. Freedom of the press in 1790 was, of course, referring to a piece of paper, a newspaper, and saying that there would be freedom to engage in that process in this democracy of America. Now that freedom of press is referring to this, and things have changed an awful lot. We have a circumstance now where people no longer have just a handful of television networks or known publications, Washington Post, New York Times and such, but turn for their sources of information to places like Facebook and Twitter and beyond. And we have a real serious question about what is a publication in America? What does it take to be a publication and be press? Is my blog that I publish tomorrow the press, guaranteed with a constitutional right that I have a right to publish it as I wish, say what I want to say with certain boundaries? And I guess my question to you as we look at this is, how do you move from the language of 1789, 1790 to the reality of 21st century and make sure it's relevant? If more people are relying on Facebook and Twitter, for example, for information than they are common sources of television and newspapers, how do we rationalize that they can say, Facebook and Twitter, to a former president of the United States, you can't publish here. You're not going to be allowed to do it, and they've done that. So how do you reconcile that conflict of the changing times, the dramatic changes in technology, what the Founding Fathers envisioned and what we face today?
Thank you, Senator. The challenges that you identify are the types of things that the Supreme Court is now dealing with. We have a foundational document that has text and it has principles. It establishes freedoms and foundational important concepts that are intended to govern us and that we are bound by as a society. There's modern technologies, as you say, that have not, that the framers, the founders could not have imagined, the cell phone and all the other things that we now rely upon. And as I mentioned earlier, the Supreme Court and every court deals with individual cases, disputes about issues, and when the court gets an issue that requires constitutional interpretation, it looks at the facts and circumstances of the particular case and the text and principles of the Constitution in light of the times in which they were written and analogizes to present day. So the Supreme Court, for example, has considered the cell phone issue with respect to the constitutional principle of unreasonable searches and seizures, which is a protection from government intrusion that the framers called an unreasonable search. The text unreasonable search does not have an inherent definition. What the Supreme Court has done is looked back at the time of the founding to determine what kinds of intrusion would have been covered when those words were written into the Constitution. And to the extent that at the time of the founding, those words covered things like police officer intruding into your home and looking into your papers and affairs, then the Supreme Court analogizes that circumstance to the modern day circumstance of a cell phone which now is in all respects, says the court, like rifling through your papers and affairs. So it's a process of understanding what the core foundational principles are in the Constitution as captured by the text, as originally intended, and then applying those principles to modern day.
I'll just give you two illustrations of my thinking on this and my frustration, or at least understanding of the challenge, let's put it that way. Senator Feinstein and I joined in legislation several years ago to talk about confidentiality of sources for news entities, and whether or not a reporter could be compelled to disclose those sources. The effort really drew some of the best and brightest in the news business to come testify for the committee. The effort failed and faltered over what is a publication, who is a publisher, who is in the business of dispensing news. Does it involve money has to pass between them for this to be an official publication? Or can I just put up on my blog what I wish and resist any efforts to discover my sources? That was one of the serious issues that we faced. We also took a look, I take a look at where this is going in terms of the future and our entities that we rely on for news so often. And I'm going to leave it at that because I think you've addressed the general and don't want to get into more specifics, nor should you. But when people pledge that, they are originalists, we're sticking with the original words, you better have your mind open to the reality that this world is changing and changed, and many of those principles are sound today, but the challenges of interpreting them with the reality of today's technology is a challenge, a very difficult one, which you would face in the court. I'm going to try to set an example here. We have 20 minutes, and I'm going to try to yield back some part of it. I see that Senator Cornyn is here, and I'm glad he is, because I'm going to address an issue which he raised yesterday and again this morning. I wanted to do it while he was physically present so that when he gets his turn, he can address it. I'm sure he will. Yesterday, Senator Graham said that you had gone too far in calling the government, quote, a war criminal and pursuing charges against a terrorist. Later, Senator Cornyn asked Judge Jackson, I quote, you referred to the Secretary of Defense and President of the United States as war criminals. Why would you do something like that? As I noted yesterday and repeat this morning, these charges don't hold up. CNN fact check said, quote, both Graham and Cornyn left out important context. Specifically, neither mentioned that Jackson's allegation of war crimes was about torture. Also, Jackson didn't explicitly use the phrase war criminal. The New York Times noted that the allegation, quote, is a distortion and lacks context. The New York Times went on to say, Judge Jackson did not specifically call the former president and defense secretary war criminals. She was one of several lawyers in 2005 signing 4 essentially boilerplate habeas corpus petitions on behalf of detainees at Guantanamo that claimed the U.S. government had tortured the men and that such acts constitute war crimes, that's in quotes. The petitions each named Mr. Bush and Mr. Rumsfeld, along with 2 senior military officers who oversaw the Guantanamo detention operation in their official capacities as respondents. Washington Post noted, and I quote, one key thing to note, as law professor Stephen Vladeck does, is that Bush and Rumsfeld are named in petitions because they have to be, to clear procedural hurdles. Indeed, those petitions later named Barack Obama after the administration changed. Another is that they are named in their official capacities, not because of actions they personally took as individuals. They continued, but the larger point is that Jackson was acting as a detainee's lawyer in her role as public defender, and one of the underpinnings of the American justice system that is even the most reviled alleged criminals have the right to a vigorous defense. Would you like to comment on that statement that I just made?
Well, Senator, I would just say that public defenders don't choose their clients, and yet they have to provide vigorous advocacy. That's the duty of a lawyer. And as a judge now, I see the importance of having lawyers who make arguments, who make allegations. In the context of a habeas petition, especially early in the process of the response to the horrible attacks of 9/11, lawyers were helping the courts to assess the permissible extent of executive authority by making arguments. And we were assigned as public defenders. We had very little information because of the confidentiality or classified nature of a lot of the record. And as an appellate lawyer, it was my obligation to file habeas petitions on behalf of my clients.
Thank you, Judge. I'm going to try to set an example by yielding back about 7 minutes of my time. I invite my colleagues to follow that example if they wish. Senator Grassley, you're next.
Yeah. Before I start, I'd like to make a brief point. Yesterday, Senator Durbin referenced Congress's effort to stop child pornography and the exploitation of minors. I've worked on this issue for decades. In 1983, I supported the Protection of Children Against Sexual Exploitation Act. In 2012, I sent a letter to the Sentencing Commission while Judge Jackson was vice chair. In the letter, I encouraged the Sentencing Commission not to lower sentences for child pornography. I said that, quote, it would be a disservice to the American people to have the Commission issue a report that advocates for the reduction in sentencing for a class of criminals who cause profound and lasting damage to their victims, end of quote. I'd like to have that put in the record.
Without objection.
Yesterday, you referred to your record of decisions as the best thing to look at when explaining and evaluating your nomination. But you also said that you haven't had enough cases involving constitutional law to develop a judicial philosophy. If you haven't had to develop a philosophy for deciding cases yet, what else do you think would be helpful for us to look at?
So respectfully, Senator, I do have a philosophy. The philosophy is my methodology. It is a philosophy that I have developed from practice. Unlike some judges who come to appellate work from academia and who have some overarching theory of the law, I approach cases from experience, from practice, and consistent with my constitutional obligations. So my philosophy is one in which I look at cases impartially, consistent with my independence as a judicial officer. I understand my limited role in the constitutional scheme and therefore take very seriously all of the constraints on the exercise of my authority that exist in our system. What that means is that at the beginning of every case, I am setting aside my personal views.
That's the 3 steps you gave us.
Yes, sir. Yes.
So you don't have to go into that. Let me go on then. Should the Supreme Court overrule a precedent when it is clear to the justices that the precedent was wrongly decided?
Thank you, Senator. Stare decisis, which is the principle that the Supreme Court uses at the outset. It's the sort of background rule of judicial maintenance of precedents in order to have predictability, stability in the law, is the kind of principle that the court begins with when it is asked to overrule or revisit a precedent. And the court has developed certain factors that it looks at before it actually undertakes to reverse a precedent. One of those factors is the view that the precedent it's reconsidering is wrong, but that's not the only factor. The court also determines, in addition to whether or not the prior precedent was egregiously wrong, the court has said, the court looks at whether there's been reliance on that prior precedent, whether the precedent is workable or has proven workable over time, whether the cases in the area of the precedent have shifted such that the precedent itself is no longer on firm foundation, and whether there have been either new facts or a new understanding of the facts that give rise to a need to revisit the precedent. So it's not just a look at whether or not it's wrong, and it's important that the court take into account all of those factors, because stare decisis, meaning letting the precedent stand, is a very important pillar of the rule of law.
When is it appropriate for a judge to impose a sentence enhancement under the guidelines?
Thank you, Senator. The federal sentencing guidelines are crafted to assist courts in making sentencing determinations within the broad range that Congress prescribes for cases, for crimes. So in the typical case, a defendant is convicted of some crime. In the federal system, they're usually very serious crimes, and Congress will say, Judge, you can give that person a sentence anywhere between 0 and 20 years, for example. The sentencing guidelines are designed to set out a series of factors that judges should be looking at when they decide what they're going to sentence that particular person to. And those factors will be things like, if this is a violent crime, does the person have a weapon? If this is a violent crime, was there any injury? And so the judge is looking at these facts, in many cases horrible facts, and calculating the guidelines based on what we call enhancements. Each one of those different characteristics or conditions is an enhancement. So you ask, when is it important to when it's appropriate? Well, the judge has to calculate the guidelines in every case. That's how we start the process. But under the statutes, in addition to calculating the guidelines with all of those enhancements, the way our system now works is you determine what the guideline range of punishment is going to be, and then Congress says you look at a series of other factors in addition to the guideline range. And at the end of the day, the judges in the system now are choosing sentences based on both the consideration of the guidelines and also the consideration of the statutory factors that Congress has put forward.
Have you ever declined to impose an enhanced sentence on a defendant because you disagreed with the enhancement as a policy matter?
Thank you, Senator. Yes, and the reason is because of Supreme Court case law concerning the way in which the guideline system operates. The Supreme Court has determined in a case we discussed yesterday that the guidelines are no longer binding on judges, meaning the guidelines you calculate, but you don't have to stay in the guideline range anymore. That was the Supreme Court's Booker case. and I can't remember if it's in that case or in subsequent case law, but the Supreme Court has also made clear that when you are calculating the guideline range in the new system that we're in right now, judges are free, the Supreme Court has said, to decide in particular cases whether, as a quote-unquote policy matter, they disagree with a particular enhancement. That is the state of the law. That is what the Supreme Court has said judges are permitted to do in cases. And so I have, in certain cases, given the way in which the guidelines are operating, the disparities that are created in cases, I have at times identified various enhancements that I have disagreed with as a policy matter because the Supreme Court has said that that's the authority of a sentencing judge in our system.
Are nationwide injunctions constitutional?
Well, Senator,
You've issued them.
thank you for letting me address that circumstance. The reason why I paused is because what I have issued is not technically a nationwide injunction. People call it that, but in a particular set of cases, administrative agency cases that are brought under the Administrative Procedure Act, these are challenges to agency actions, like agency rules that they have promulgated. And if the challenge is to the procedures that the agency undertook to create the rule, the statute that applies, the Administrative Procedure Act, tells the court that if you agree with the plaintiff that the agency rule is faulty procedurally, the remedy in the statute is to invalidate the rule. That's what Congress tells judges to do. Now, technically, that's not a nationwide injunction. That is invalidating a rule that the agency has enacted. It may have nationwide effects because the agency may have implemented its rule nationwide. But what the court is doing is not reaching out and touching everyone in the country. The court is directing the government that has promulgated that rule that the rule is invalid. And that's what the statute tells us we have to do in those cases. That's different than a nationwide injunction because a nationwide injunction would be a situation in which we're not dealing with the rule, we're not dealing with the Administrative Procedure Act, we're dealing with a particular case in which something has happened between the plaintiff and the defendant, and the court says, based on what happened in this case, I'm going to tell everybody in the country that you can't, the defendant, you can't operate in this way anymore. I'm going to find on the basis of this particular case, and I'm going to enjoin everyone in the country not to do that anymore. That's a nationwide injunction, which is not what I've done in, I think, the cases that you're talking about.
How can the judiciary address concerns about forum shopping given the rise of nationwide injunctions?
Well, forum shopping is a concern that arises when litigants seek to go to different places in the country where they think that they may get a better result. And it's something that Congress can address because Congress has the power to determine various aspects of judicial process.
Explain the political question doctrine, and then what standards would you apply to determine whether a claim before you implicates a political question?
So the political question doctrine is a doctrine that relates to the jurisdiction of the court. As I mentioned, the courts are in a particular branch of government, the judicial branch, that is limited in its power. The courts can't make policy. They can't reach out into the world and decide that certain things are good or bad and then address them. They have to wait for cases to come and decide them. And when a case comes, it has to be presenting a question of law for the court to answer it. If a person comes to the court and they ask the court to answer something that is properly in the province of Congress, if they ask a political question, then the court has to say, I'm sorry, that's not my role. So I had, for example, a case that involved Yemeni citizens who, I'm trying to get the facts exactly right, but they had relatives. I think they were resident in the United States, and they had relatives in Yemen, a war-torn area. This is a few years ago, and they came to the court, me, asking if I could direct the administration to extract their relatives from Yemen, that they wanted me to order the executive branch to send in troops and get their relatives out, because it was obviously dangerous for their relatives to be in that country. And what I said in that circumstance is, essentially, I don't have jurisdiction to do that, because what you're asking me to do is a political question. That the question of when and where troops can be sent and who can be extracted from foreign governments belongs with the executive branch. And so you have to ask them. And so I said I have no jurisdiction. That's a political question, doctrine, and it's well established in our law.
Yesterday, in response to a question from Senator Durbin, you said that as a judge, you are, quote, trying in every case to stay in your lane, and end of quote. That's the same time you gave us the 3 steps you go through as you work yourself through a case. You also described the text of law as a constraint on your authority. But in several cases, I'll list Make the Road, New York, AFL-CI versus Trump, Watervale Marine Companies, and others, the D.C. Circuit reversed your decision or criticized your reasoning for failing to follow a clear and unambiguous text. Why didn't the clear text of the law constrain your authority in these cases?
Thank you, Senator. You mentioned 3 cases. Certainly with respect to the second one, the D.C. Circuit didn't say that the text was clear, and in fact, that's what happens in cases, that judges at the trial level do their best to make interpretations. In that case, it involved a channeling provision. This is AFG versus Trump. It involved a provision, a statute that was designed to channel the judicial authority into an agency. And I interpreted the statute, and I thought that the arguments that were being made, the claims that were being made, were not ones that Congress had intended to channel. And I went through the analysis, and I explained my reasoning as to why I thought I still had jurisdiction, and I went on to address the merits, which is the duty of the judge if they determine they do have jurisdiction. The D.C. Circuit disagreed. They wrote an opinion that interpreted the statute differently with respect to those claims, but it was a case of first impression as to what those claims meant and whether they were supposed to be channeled or not. And that happens. District judges do their best, and sometimes the Court of Appeals and the Supreme Court haven't spoken to the issue, and the parties disagree. In Make the Road, I explained that what I was attempting to do in light of Congress's enactments, not only the particular immigration provision, but also the Administrative Procedure Act, was reconcile the statutes of Congress, which is something that the courts also are supposed to do. That there are statutory interpretation canons that make clear that courts are supposed to understand that Congress intends for its statutes to work together, and to the extent that you are interpreting and the claim is made that allows you to do that, that's the sort of way in which interpretation is done. I can go through my actual analysis. I did it yesterday as we talked, but there was a good faith disagreement between me and the Court of Appeals, which gets to decide as to what the language meant and whether or not Congress actually intended to exclude the APA using that language under those circumstances.
Thank you very much.
Senator Leahy.
Thank you, Chair. And welcome back, Judge Jackson. I know yesterday was a grueling day of questions. I commend you for your poise, your endurance, your thoughtful answers. I felt privileged to be here for hours of that, and you had even more hours. But I want you to know the reaction in my own state of Vermont. I've gotten all kinds of emails and calls and from friends across the political spectrum. They're all been praising you. And they said they realized that a lot of the questions that were lobbed at you had nothing at all to do with your qualities as being on the Supreme Court, but were some members, unfortunately, aiming for what a soundbite that they might be able to put on a political website where it now is. For example, we heard some overheated claims yesterday that your representation of Guantanamo detainees somehow signaled your policy preference with how the United States has dealt with those detainees. Every single member of this committee, especially those of us who have been assigned as counsel in cases, should know better than to conflate a nominee's past representation with their policy positions, or to argue that a nominee espoused their client's viewpoint simply by choosing to represent them. So your policy views aside, can you reiterate why it's so important for our courts to have the benefit of the best possible legal representation on both sides of any case, and especially in cases where we are in uncharted legal and constitutional waters?
Yes, thank you, Senator. So I've been a judge for almost a decade, and what I've learned is that as part of my duty to render decisions consistent with my judicial oath in support of our Constitution and the rule of law, I need to consider all of the arguments related to the dispute that is being brought in my courtroom. I need to hear from not only the parties who are prosecuting a case, for example, a crime, but also from the defense. And some of these crimes are terrible crimes. Our Constitution is designed to ensure that the government affords due process to people who are being accused of crimes. And one might think it's even more important in a way in a case in which someone is so reviled. It's kind of like the First Amendment. It's a protection for unpopular views. It's needed when there's a chance that the government will suppress or do something that's untoward. And so in the criminal justice system, we have many, many amendments that are designed to make sure that unpopular people, people who are accused of doing terrible things, are still treated fairly by the government. And that's a limitation on government power, which is the framework of our Constitution. It is about limiting government overreach. And so in the criminal justice system, you can imagine, and the framers imagined, a world in which the government would use its authority to deprive people of their liberty, to throw people in jail, to lock them up and throw away the key, to not give people the opportunity to make arguments about their freedom. That would be a real exercise of government power, government overreach. And so the framers said, what we're going to do is we are going to put in our foundational documents a protection for people that the government is accusing of crime. And that's not to say that the people are innocent. That's not to say that they haven't done terrible things. What it's about is ensuring that the government does what is required in order to ensure all of our liberty. It protects all of us because there might be someone who is innocent, and if the government is able to just do whatever it wants in criminal process, we are all at risk.
Well, and I think we've all seen cases where that happened. I mentioned to you yesterday that I spent nearly a decade as a prosecutor. And especially when I had serious cases, I wanted the best defense attorney possible on the other side. I wanted a case that if I won, it usually went up on appeal automatically if it carried a heavy penalty. I wanted the court, the appellate court, to look at it and say, okay, there were not errors of counsel on either side. But I also, as a strong proponent of our Constitution, I think what you're saying is something I totally agree with. We have to have the individual's rights protected. It doesn't mean the defense counsel is in favor of murder or rape or armed robbery, but the rights have to be protected. And let me tell you about another area. I've authored and I've long championed the bipartisan John Lewis Voting Rights Advancement Act. I think it would help curtail the growing wave of voter suppression sweeping across our country. Again, something we don't have to worry about in Vermont, but unfortunately do in other states. I'm passionate about this legislation. I've always believed that our democracy is stronger when we expand, not shrink, the ranks of our citizens who have fully participated. I believe our democracy goes stronger with your historic nomination and your presence before us today. And I've told you privately how my family members feel about that. Why is it important for our democracy's institutions, courts and all others, to reflect the rich diversity of our nation's citizenry?
Thank you, Senator. One of the things we've been talking about is the difference between the judicial branch and the other branches of government. We have three branches in our federal system, and the legislative branch has certain powers and it can do certain things to ensure that its prerogatives are achieved. And the executive branch has the power of might. The president controls the military. The judicial branch, its force in our system is the protection of the rule of law, which can only be done by essentially the consent of the governed. It can only be done if people in our society believe decide and agree that they're going to follow what it is that courts decide. And so one of the reasons why having a diverse judicial branch is important is because it lends and bolsters public confidence in our system. We have a diverse society in the United States. There are people from all over who come to this great nation and make their lives. And when people see that the judicial branch is comprised of a variety of people who have taken the oath to protect the Constitution and who are doing their best to interpret the laws consistent with that oath, it lends confidence that the rulings that the court is handing down are fair and just, that everything has been considered, that no one is being excluded because of a characteristic like race or gender or anything else. And that's important. I would also say that that it's important from the standpoint of role modeling, that I have been so touched by the numbers of people who've reached out to me in this period of time to say how much it has meant to their daughters, to their sons, to the next generation, that I've been appointed, nominated, and hopefully confirmed.
Well, I agree with you. I've certainly seen that within my own family. You know, we do have areas where we agree on things on this committee. Senators Grassley and Senator Cornyn, myself and others believe in transparency as part of our democracy. We've done this with the Freedom of Information Act, when we've updated it a number of years. Senator Cornyn and I have been the key sponsors of legislation, joined by Senator Grassley and Senator Durbin and others, to improve the Freedom of Information Act. You've talked about the detailed opinions you've written to try to do the same thing. I think it's safe to say you believe transparency is central to the duties of a judge. Do you intend to carry that attitude and you will become a member of the U.S. Supreme Court?
Thank you, Senator. The value of public confidence, which I was just discussing, I think is enhanced when the public understands the reasons that a judge renders his or her ruling. One of my mentors used to say, people think the judicial branch is so secretive, but in fact, the judicial branch is the only branch that actually has to tell everyone, that actually has to write their opinions and explain why it is that they did what they did. And so I've tried in the nearly 10 years that I've been on the bench to make my rulings transparent, to explain all of the inputs that I have considered with respect to the case, to lay out the law as I see it in interpreting what Congress, for example, has done in with respect to a particular case, and what legal provisions that I think are relevant to the dispute, and then to explain my analysis. Why am I granting this motion or denying this claim? And my hope is that it will help people to be confident in my reasoning, and even if they disagree with it, they will understand what it is that I think, and I think that's important for public confidence in promoting the rule of law.
Well, you know, you had talked about your clerking for justice prior, how it opened up doors of opportunity. I remember so well our conversation in my office, in the President Pro Tem's office, talking before these hearings began. You told me what you thought it meant to your parents and your family, your husband, your daughters, your parents who have been here throughout this, and what it would have meant to your grandparents. You said you were the lucky first inheritor of Dr. King's civil rights legacy. I keep a daily journal. I wrote that down. It means a lot. So let me do this sort of an open-ended question. You patiently answered our questions this week. I told you the reaction in Vermont was disappointment in some that were obviously political. I heard that from both Republicans and Democrats because they think it should be your legal thoughts in the Supreme Court. So I'd like to give you an opportunity to speak directly to the American people, including our little state of Vermont. Is there anything you want to convey to them about what kind of Supreme Court justice you would be if and when you're confirmed? It's all yours, Your Honor.
Thank you, Senator. Well, first, let me just address my comments to you in your office, which is something that I've said in speeches because it speaks to who I am and what I value. My parents grew up in Florida under lawful segregation. And what that means is that when they were coming through middle school and high school, they were not allowed to go to school with white students. This is in the era before and right after the Brown versus the Board decision. There was lawful segregation in places in this country. And it was after that time that Dr. King made his famous comments that people mention about having a dream where people can be judged by not by the color of their skin, but by the content of their character. And I then was born in 1970, and the contrast between my reality growing up in Florida and my parents' reality growing up in Florida, like night and day in terms of the opportunities that were available to me that weren't available to Judge Motley, who is one of my role models in the law. And so what my being here, I think, is about at some level is about the progress that we've made in this country in a very short period of time, I would say. It seems like a long time, but one generation, we've gone from the reality of my parents' upbringing to the reality of mine. And I do consider myself, having been born in 1970, to be the first generation to benefit from the civil rights movement, from the legacy of all of the work of so many people that went into changing the laws in this country so that people like me could have an opportunity to be sitting here before you today. What I would hope to bring to the Supreme Court is very similar to what 115 other justices have brought, which is their life experiences, their perspectives. And mine include being a trial judge, being an appellate judge, being a public defender, being a member of the Sentencing Commission, in addition to my being a Black woman, lucky inheritor of the civil rights dream. And in my capacity as a justice, I would do what I've done for the past decade, which is to rule from a position of neutrality, to look carefully at the facts and the circumstances of every case without any agendas, without any attempt to push the law in one direction or the other, to look only at the facts and the circumstances, interpreting the law consistent with the Constitution and precedents, and to render rulings that I believe and that I hope that people would have confidence in.
Thank you. And Chair Durbin, I've had the opportunity to be here. The first justice I got to vote on was John Paul Stevens, nominated by President Gerald Ford. Proud to vote for him. And it's a long arc, Judge Jackson, but I am so proud of your answers, and I appreciate you. Yield back.
Thank you, Senator Leahy. Let's take a break for about 15 minutes.
Thank you.
Thank you very much, Judge.